I call today's meeting of the Public Service Subcommittee to order. Madam Secretary, would you please take the roll?
Alexander, Dixie, Eldridge, Johnson, Kiesling, Powers, Rudder. Chair Lady, you have a quorum.
Thank you. Do we have any personal orders or recognitions from any of our members today? Any personal orders? Seeing none, we'll now take up our regular calendar. Up first is item number 1, House Bill 1692 by Chairman Farmer. Do I have a second? You have a motion and a second. There are no amendments filed, so Chairman, you're recognized to explain your bill.
Thank you, Madam Chair. Members, it's a pleasure to be in front of the committee so far.
So far, so good.
I'm curious. I've got a House Bill 1692. That's an administration bill. This comes from the Department of Tourism. Right now, Department of Tourism, as we're doing a lot in the state, we're growing. And with regards to growing, we've got to visit with people, meet with different sorts of, say, airlines and just parts of tourism that want to come in to relocate here. With regards to doing that, as we're Department of Tourism, maybe sitting in meetings with these folks, there may be some confidential information that the folks that we're enticing to relocate to Tennessee may be hesitant to disclose on the front end. What we want to do is to provide them some privacy and some protections just on the front end of that for they'll feel comfortable sharing with the state the information we need and to make the decision on how maybe we can work out some sort of partnership. So that's what this bill does. It's similar to what ECD does right now currently. So I just asked this committee to pass this forward.
Thank you for that explanation. Members, do we have any questions? Yes, Representative Dixie.
That's okay. Thank you. Representative Farmer, I totally understand what you're doing with this bill, but it's especially in this day and age where there's this distrust in the government, saying that we're going to kind of keep something private, it kind of, the optics aren't right, but I understand why you want to do this to try to stay competitive against other cities. But I truly understand what's going on, but it's just a little bit hard for me to kind of support that in this.
You're recognized.
And I appreciate your concern, Representative Dixie, but it's not that we're keeping governmental information private. What we're trying to do is keep private business information private right up until maybe we can come to some sort of agreement where then they would come into the state in some form or fashion. And once that was done, then we would need no need for these sort of protections here. But we're not protecting or hiding government information from the public. We're protecting trade secrets, maybe that belong to private corporations. We're protecting their maybe financial information that other companies could use against them. So it's not that, in my opinion, it's not that we're hiding any sort of governmental information from the public. It would just be that of private companies in the negotiations between the state and them in order to try to relocate here. So thank you, Madam Chair.
Any more questions? Representative Powers.
Yes. Thank you. And thank you for bringing this forward. I got a ton of emails on it, of course. But the thing about it is, and correct me if I'm wrong, what we're trying to do is protect proprietary information from companies that may not want to reveal, like you were talking about a moment ago. We want companies to come here, but if we do not protect that information, they are going to be very hesitant about trying to give any kind of information like that. And we're not trying to hide anything. Everything will be revealed once the grant or once it's approved or of any kind of allocation for them. All of that will be revealed. But you could understand why we would want to protect that proprietary information. And like you said, and correct me if I'm wrong, didn't you say ECD had been doing the same thing for what, 30 years or something like that, that they have that same type of protection right now?
And thank you, Madam Chair, and thank you, Representative Powers. I couldn't have said it better. You were spot on your explanation with regards to the intent of this legislation. And yes, it's my understanding that ECD has been doing this for quite a bit of time.
Okay. All right. Thank you, Madam Chair.
Do we have any more questions? I do have testimony. We've had a request for testimony on this legislation, and so without objections, we're going to go out of session to hear from Deborah Fisher. Please state your name and who you're with for the record, and you have 3 minutes for your testimony.
Hi, I'm Deborah Fisher. I'm with Tennessee Coalition for Open Government. The bill has a provision in it that allows the Tourism Commissioner to keep secret any record, not just proprietary information or trade secrets or information from private businesses, confidential, if the Commissioner decides that the information is sensitive. And we are not opposed to all parts of this bill. We're not opposed to the part that allows for confidentiality until negotiations have been completed and an agreement is signed. We're not opposed to making confidential proprietary information, trade secrets, marketing information, capital plans, and any other business information that the company submits to the state with the idea that it might be confidential. What we're opposed to is in C1 and C2, which allows the department to completely sidestep the public records law by deciding that some information is too sensitive. The commissioner gets to make this call with only affirmative agreement by the AG. They say that this is modeled off of an ECD exemption, but it goes farther than even the current ECD exemption, which allows that information to be confidential for only 5 years. The Tourism Department wants 10 years, and they also have a vaguer, broader definition. ECD is limited to information that would seriously harm the ability of the state to conclude agreements, but the tourism definition of sensitive is this anything that would adversely affect. This will keep confidential information not just from the public of any record, audits, performance measures, anything. It will keep it not just confidential from the public, it will keep it confidential from lawmakers. And once that is in law, even if you think that this commissioner is going to give information out, this will last for the entirety of the years. This will last forever. So we're opposed to only one part, section C.
Do we have any questions from our members? Seeing none, thank you for your testimony.
Thank you.
We'll go back into session. I think questions been called. I think we're ready to vote. So all of those in favor, please signify by saying aye. Aye. Those opposed, signify by saying no. The ayes have it, and you move on to full committee.
Thank you, Madam Chair. Members, appreciate your time.
Next up is item number 2, which is House Bill 1887 by Chairman Boyd. Do we have a motion and a second? We do. There are no amendments filed, so Chairman, you're recognized to explain your bill.
Thank you, Madam Chair, lady and committee members. This bill is a cleanup bill that fixes 2 areas of Tennessee statute with regard to the Tennessee National Guard. The first one is dealing with USERRA, which is the law that allows soldiers and airmen that are called to active duty to get reemployed when they come back. There was a little bit of a discrepancy, and it only applied if they were involuntarily called up. So this would change it so that if they volunteered to go on orders, it would also extend that protection to them as well when they come back. The second portion is kind of the workers' compensation within the military. And so it was a little bit different. If a soldier or an airman was on state orders and they got injured, the length of their benefit had to match the period of time that they were on active duty. So this just changes the law and puts them more under what traditional workers' compensation would be. And it also makes a provision so that if a member's civilian payroll would be a lot higher than what their military pay is, we will pay the higher of the two when it comes to paying the benefit. And Madam Chair, lady, that pretty much sums up the bill. I'll take any questions.
Okay, do we have any questions? Chairman Kiesling?
Thank you, Madam Chair. Chairman Boyd, that would also apply to long-term disability, I assume, the higher of the two. Now, I think most people got it, just an injury, but what if we have a long-term disability here? Would that be a settlement, or a payment for those would be the higher of the two?
You're recognized.
Thank you, Madam Chair, lady. So this just applies to this would apply to the workers' compensation portion of it. So if it got, actually that
Well, that's what, yeah. I
Yeah, that's
know.
actually, I was about to answer that, but I think what I'd like to do, I do have some folks from the military department that may be able to answer that better. I'm not 100% sure on that when it applies to our service members. So did you have another question? And then,
No, I
so,
did not, Chairman.
Madam Chair Lady, if you don't mind going out of session, I do have JD Cressman here. I think he's on the list.
Sure, we'll go out of session. And would Mr. J.D. Cressman please come up? Please identify yourself for the record and who you're with, and you have 3 minutes. There you go. You good?
There we go.
There you go.
It blinked at me. Okay. Yes, my name is JD Cressman. I'm with the military department and I'm an attorney in that agency. To your question, so when we were researching this, the benefit that was at issue under our workers' comp law was temporary total disability. So, there is temporary partial disability. There are an array of disability benefits that a member may receive under workers' comp. But so long term, does that fall within workers' comp or is that under a separate program under TennCare? I may need some help from the committee because when I was examining this, it was specific to workers' comp. And so we were looking at temporary total disability, temporary partial disability. I don't recall that. Forgive me, but I was thinking that was a TennCare benefit.
Thank you, Madam Chair. John, well, I can't answer that question. I mean, you're posing that question to me, and I'm sorry.
I'm happy to look into that further.
Well, okay.
And examine it. So this is.
Shall we, Madam Chair,
Sure.
could we go out of session for just a moment?
We're out of session.
Oh, well, that's right. Excuse me.
So you're perfectly okay. We're going to hear from legal.
Thank you, Matt Mundy, for the record from legal. I don't believe this applies to long-term permanent disabilities. I think as I understand workers' comp, we're talking about temporary, partial, and total disability.
Okay, that's good.
Any more questions, Chairman Keesling?
No.
No,
thank you. Thank you, Madam Chair.
You have questions? Anybody? No other questions. So
Thank you, John.
we'll go back into
Yes.
session. And I think okay.
Madam
You're
Chair Lady, I did want to speak to that, and I may know the answer to that. I thought JD might have a better answer for me, but I know that if you're on federal orders and you get injured, the VA has a disability benefit that would apply. With these being under state orders, I think that it would fall just like once the workers' compensation benefit had been paid out, they would be subject to Social Security disability, or if there were an insurance policy in force. But I don't think that workers' comp would pay them into perpetuity.
Representative Powers.
Thank you, Madam Chair. Just clarify for the committee and what you were talking about a while ago about the greater of the two, when they do it, what percentage that includes, and when they pay out workers'
You're
comp,
recognized.
what percentage of the actual salary is paid out?
Thank you, Madam. Thank you, Chairman and Madam Chair Lady. So when it does pay out, it's ultimately 2/3 is what the benefit is under traditional workers' compensation. And does that answer your question?
Yeah, I
okay.
thought it was 60%, but you're probably right. But it's going to be the greater of the two. It's going to pay that percentage of that. Right.
Yeah.
Correct.
Yes,
Yeah.
you're recognized.
And that's a new provision that we put in there. That's really good. And this benefit's paid out very rarely because this is not an overseas deployment. This is someone that's been called up for a national emergency or is on state orders. So it's probably really rare that something like this would pay out, but I think that's a really nice gesture that we're doing that I'm not sure other states are doing, that says, if you come from a profession where you make really good money, but you're giving up that job for a short period of time to get paid at a lower amount and you get hurt, we don't want you to have to try to, pay your bills off that lower amount. So I'm pretty proud of this.
Okay. Yeah.
Exactly.
Thank you.
Thank you for bringing this bill.
Yes.
So I think with no objections, Dix, I'm so sorry. You go right ahead. Representative Dixie.
Hey, just a quick comment. A lot of us here leave high-paying jobs to come work for peanuts. I'm just wondering, does that work for us? Because there's a lot of PTSD around here too as well. Just wondering.
Thank you for that. Do we have any more questions from any of our members? Seeing none, I think we're ready to vote. All in favor, please signify by saying aye. Aye. Those opposed signify by saying no. Ayes have it, and you're moving on to full committee.
Thank you, Chair, Lady in Committee.
You're welcome. Next up, we have item number 3, which is House Bill 2088 by Chairman Reedy. Do we have a motion? We have a motion and a second, and there are no amendments filed. So, Chairman, you're recognized to explain your bill.
Thank you, Madam Chair and Committee. For context, I want you to know, and of course, I talk about my military career in the past, but I started out in the Idaho National Guard, later went active duty, and then from there went Army Reserve. And what we find currently, when we spend a lot of state and federal dollars to train men and women in the armed forces, a lot of times we want to retain that individual, so we talk about retention. So at the federal level for reenlistment time, there's reenlistment bonuses for active duty military. But once we come down to the state guard, that's what this bill is pertaining to. And I'll read so we know exactly what it's doing. It's covering 2 areas. It authorizes the Department of Military to administer critical care skills retention bonus program to award additional retention bonuses to enlisted service members in the Tennessee National Guard. It also entitles a state employee ordered into active duty or retained on active duty to the President of the United States or under the authority of the governor as a member of a reserve component of the U.S. Armed Forces, the Tennessee National Guard, to special leave with partial pay during the period of active duty, not to exceed 1 year. Defines partial pay as the difference, if any, between a state employee's regular state salary and the employee's full-time active duty military pay, with a minimum monthly amount sufficient to keep a full force and effective of all state benefits that the employee had on the date of the call to active military duty. Which means is if that employee with the state gets called to duty, and of course there's special skills that we want to retain at the state level, but when they get on active duty, that job as a military man or woman is less than what they currently make at the state level. And if they're gone for a whole year, it could be a financial burden to that family as that soldier is on that leave. So I will stand for questions.
Q, do we have any questions? Seeing none, are we ready to vote? Okay. Question's been called. All in favor, please signify by saying aye. Aye. All opposed by saying no. The ayes have it, and you
Madam
move
Chair,
on to full committee.
Thank you.
Next up is item number 4, which is House Bill 2828 by Leader Camper. Do we have a motion and a second? We do, and there are no amendments filed. So, Leader, you're recognized to explain your bill.
Thank you. Thank you, Madam Chair, committee members. House Bill 2828 is a bill that establishes the African American Cultural and Historical Grant Fund to be administered by the Tennessee Historical Commission. The purpose of the funds is to support capital projects at facilities in the state that highlight the contributions, culture, and history of African Americans. Money in the fund may also be used by the Historical Commission for program administration, marketing expenses if they want the program to be evaluated. However, such expenses may not exceed 5% of the total amount appropriated every year. The commission may establish and publish guidelines for the application, including eligibility, the awarding of the grants. Priority will be given to projects to encourage design and construction of new facilities or to renovate existing facilities that have a great significance, cultural significance for that facility. This bill requires that the commission may submit or should submit an annual report to Finance, Ways and Means every year by March, and it will authorize it to promulgate rules to effectuate this bill.
Thank you for
Take
that
any questions anybody
explanation.
may
Do we
have.
have any questions? Chairman Kiesling?
Sir.
Thank you, Madam Chair. Appreciate it. Leader,
Sir.
good bill.
Thank you.
I just wish, and I'd love to support this. I can't at the moment due to, I just wish we had have included, or you would have included the Asian community, the Hispanics, and You get me.
I do. Yeah.
So, as in its current form, I just can't, and I want you to understand that. Thank you,
I appreciate that.
Madam Chair.
We have a question from Vice Chairman Eldridge.
Thank you, Chair Lady, and to Leader Camper. This is I mean, you can use this grant to restore historic buildings that are related to the African American communities and that type of thing. Is that correct?
Yes, sir.
Okay. I'm going to come at it a little different angle from Chairman Kiesling. Up in East Tennessee, we had Morristown College. It was established in 1881, and it was one of two institutions in East Tennessee. The other one was Knoxville College. It was an integral part of our community. Judson Hill worked hard to bring a community together to support Morristown College. He went up north. He got the Carnegies, he got the McCormicks, the Kellogg's to contribute money to help establish this school. And I learned a little bit of history on it too, was, when we were, going back looking at some things. 7 of the 9 buildings that was on Morristown College, or Morristown's college campus, was on the National Registry of Historic Places. They're all gone. It fell into ruin after it was abandoned in 94. It became a hangout for drugs, just whatever. It was and I had the privilege of working up there on the buildings. We went and worked and fixed windows that were vandalized and everything. Some of the architecture was just absolutely beautiful. The gymnasium had probably some of the prettiest hardwood floors I'd ever seen. So I kind of wish there'd been something there, that there'd been more of an action taken to preserve that school, and it might not have survived as a college, but it could have been our community center. It could have been a lot of things before it fell into disrepair, and it's a park now. It's actually named after a gentleman that was sold as a slave on the property. He went to school there. He became an instructor there. And then Dr. Hill, who had helped get the college up and going. So we lost a lot of history right there. And then in Granger County, we have Henderson Chapel AME Zion Church. And thanks to the efforts of Clinch Powell Resource and Conservation Development Council, that church is being saved from total ruin. And it was established in 1890. So I'm going to support this. I see a need. I think it's important that we preserve all of our history, not just some parts of it or anything like that. But this was and living there as long as I have in Morristown, I watched the college go absolutely to nothing, and it was a very important part of our community. So I will be supporting it.
Thank you, Madam Chair. I guess the question I have is kind of with the financial part of it. I was looking at the note earlier today, and it looked like it was talking about increasing state revenues, $475,000 a year, but expenditures the same. So it's kind of a wash there. I was just wondering, what are some of the things that are going to be done to increase the state revenues? I mean, to make this self-sufficient, or it's paying for itself almost.
You're
Thank you.
recognized.
Yeah.
Thank you, Madam Chair, and thank you for your comments. I really appreciate them. So with this fund, the way the grants could be set up is they can use the money for matching dollars to pull down, to leverage other resources. In the case you described, if this was available, they could have reached out for a grant and then went out to get some matching dollars to do that. I expect that there would be some advertising for tourism around this. We have a place in Memphis that is on historical registry now, that if it was able to take advantage of this, we would be able to restore some of the windows, restore some of the things that took place in there, and then it can become a tourist attraction for it can so that it can generate funds for itself to be self-surviving. And there's people talking about, how Tennessee is this great tourist place, which it is. But there are a lot of people who come here who is looking for African American history to visit and tour. This would allow the state to be able to actually do that in a real way. I had a meeting scheduled for tomorrow with the governor to talk to him about this funding. We had to reschedule because he's going to the funeral for the gentleman up in Blount County, I think it is. But this is something that I think he might be interested in funding. We had a meeting set, so hopefully I'll be able to at least get the seed money coming, and then we can use it because the fund to be able to go out and get other dollars to bring it back in. So
Okay.
that's the strategy at this point.
Okay. All right. Thank you.
Do I
Thank
have
you,
any
Madam
more
Chair.
questions? Question's been called. We're ready to vote. All in favor, please signify by saying aye. Aye. Those opposed, no. We have, if you would like to be recorded as a no, please see the clerk, and your bill is going to pass out to full committee.
Thank you, Madam Chair and committee. Representative, we can talk. Let's talk later and see what we could do. Yeah.
Next up is item number 5, which is House Bill 2006 by Chairman Haston. I don't think he's chairing a committee right now. We're going to roll this House Bill 2006. We're going to roll that to the hill. Item number 6, which is House Bill 1828 by Chairman Reagan, has been rolled for 1 week. Item number 7, House Bill 2890 by Chairman Todd, that has been taken off notice. And now that brings us to item number 8, which is House Bill 2588 by Chairman Russell. Do we have a motion and a second? We do, and there are no amendments filed, and so Chairman, you're recognized to explain your bill.
Thank you, Madam Chair, lady in committee. House Bill 2588 would add an exception for the Tennessee Consolidated Retirement System members who hold an elected or appointed board member position with a special school district or local government to retire from another TCRS employer and begin drawing benefits without resigning their elected or appointed position. And with that, I'm ready to take
Stand
questions.
ready for questions. Do we have any questions? Looks like you have no questions. Well, questions been
Thank
called.
you.
We're ready to vote. All of those in favor, please signify by saying aye. Opposed? No. The ayes have it. You move on to full committee.
Thank you.
You're most welcome. See, Chairman Haston is in the building, so we're going to go back to item number 5, which is House Bill 2006. Do we have a motion and a second on the bill? We do. There are no amendments filed. Chairman, you're recognized to explain your bill.
Thank you, Madam Chair. Sorry for in and out. Having K-12 sub at the same time has made it a little bit tough. This bill simply adds the bluegrass legends Wayne Gerald's song Tennessee, Tennessee to the list of official state songs. I'll be brief, tell you a couple quick things about him. He toured with Bill Monroe and Tammy Wynette, and he's won the Tennessee, Mississippi, and Alabama state fiddling contest, has been on the stage of the Grand Ole Opry over 100 times. And with that, I'll be glad to answer any questions.
Do we have any questions for our sponsor? Questions been called. Okay, all of those in favor, please signify by saying aye. Opposed? No. The ayes have it. You move on to full committee.
Thank you. I'll see
You're
if
most welcome.
Ms. Terry Lynn can come back and take care of that for us. Thank y'all.
Before we move on, item number 6, which is House Bill 1828, there has been a correction. That was actually House Bill 1841, and that bill has been rolled for 1 week. That brings us to item number 9, which is House Bill 2315 by Chairman Williams. Do we have a motion and a second on this bill? There's no amendments filed. Chairman, you're recognized to explain your bill.
Thank you, Chair Lady. and it comes to you from pensions with a positive recommendation. This bill authorizes the state of Tennessee's 457B and 403B plans to comply with the requirements enacted by Congress's Secure Act. Additionally, it allows for the establishment of non-qualified deferred compensation plans called 457Fs of the Internal Revenue Code, which would provide tax deferred compensation for employees who are highly compensated or in management positions. With that explanation, I'm happy to answer any questions members might have.
Do we have any questions? Looks like you have no questions.
Thank you, Chair Lady.
Question's been called. All in favor, please signify by saying aye. Aye. Those opposed, no. The ayes have it. You move on to full committee.
Thank you, Chair Lady members.
Next up, we have item number 10, which is House Bill 2716 by Representative Garrett. We have a motion and a second. There are no amendments filed, and Representative, you're recognized to explain your bill.
Thank you, Madam Chairman. House Bill 2716 is a fairly simple bill. When there's a vacancy created by an expulsion here in the General Assembly, Article 2, Section 15 describes what happens in that event. And in that event, a successor is appointed by the local authority. And the language in that particular provision says that it's actually a successor. So here you cannot succeed yourself. And I would further let the committee know that under Article 2, Section 15, it also references the replaced legislator. So in a sense, you can't replace yourself. So I believe this is crystal clear that if you are expelled for disorderly conduct, you cannot succeed yourself or you cannot replace yourself. So what this bill simply does is clarify that an appointing body, if someone's expelled, cannot be reappointed back to that same General Assembly. So with that, Madam Chairman, I'll be glad to take and answer any questions.
Do we have any questions? We do. Representative Dixie.
Ooh, seems like we've been down this road before. Like deja vu. I have an issue with this because, again, we always say we don't want to mandate and do things and step on the local communities and local agencies. But here we are again, not just stepping on it, but jumping up and down on it with 2 feet. And again, this says the local legislative body picks who they want to decide to represent them. Again, we're going to take their will away and impose the General Assembly's will on this. And again, I hesitate this because you're not going to always be in a super majority. And eventually the tide will turn. And I just feel that the way that we can expel people just because you have the votes and you can come up with reasons to make that happen, this is a very slippery slope that we're doing. And I hesitate for us to continue down this road. And then again, as I spoke with the other bill that was, I guess it's the constitutional amendment that is very similar to this, eerily similar to this. How do we keep going down this road? And it just seems that if this was an issue, why isn't it an issue at this point now and it wasn't something that was before? It seems very vindictive, and it seems petty that you would do this at this particular time. And I just would hope that you would think this, and let's think through this and what the unintended and intended consequences are of this. And I just feel like we have no right to take away the will of a local district of who should represent them. And I think that's what we're doing. We're pushing a hand on the scale. And it seems like every time something doesn't go the way that someone wants to do it, we change the rules to put our thumbs on the scale. And I would hope that we would learn something from the past and that we can move forward and not backwards. And I feel like this bill is going to push us backwards, and it's going to continue the bad energy and the animosity that we have in trying to get things done for Tennesseans. So I would hope that you would reconsider this, but because of those reasons, I can't support this bill.
Representative Garrett.
Thank you, Madam Chairman. And I appreciate your comments, and I would agree with a few of them as saying that no one should absolutely be expelled just because one side or the other has the votes. That's not what this bill is about whatsoever. So the conduct that we all are bound to act when we're here is the basis of this. And there is a question, right, of whether or not this language is applicable to the person that has been expelled. I don't know if you've read that particular provision that I'm referring to, but it is clear in my eyes that it's not someone that can succeed themselves, and even references a replaced legislator. That language drafted by our founders, there's no way that intent was that you can replace yourself as it relates to what this bill is accomplishing. So it's simply just clarifying to make sure that if someone is guilty of disorderly conduct that rises to the level that we believe, or there's enough votes to expel that person for their conduct, this clarifies what that role will be should they be expelled, where the local authority, they can pick anybody they want to. It doesn't limit that. It's just the Constitution says you can't succeed or replace yourself. So it's just simply clarifying what's already in Tennessee state constitution.
Thank you, and I appreciate that. I don't think it clarifies anything. I think that you say it in a very calm manner, and I like the way that you present the things, and it keeps everything down and keeps us at a conversational tone, and I truly appreciate that, because that's what needs to happen is conversation. And I just think that given what's happened in the General Assembly over this last year, I think we should just give a little pause to this and what we do, because what we do here is so permanent. And hopefully, that will not happen again. But I understand that what we keep doing is something that's very reactive. We are reacting to something because something happened. Man, we forget what was the cause, what was the root cause of that incident. And I think we have to go back that if we look and we're fair with each other and just have an honest conversation to say, did we give everyone an opportunity to weigh in on it? Did we give everybody, because it was a highly emotional charged time. And I think if we could all, I would hope that if we could all go back, a lot of people would say, I would do this differently and I would do that differently. But I think we have to just give a little pause before we do this and we ram this again down the throats of Tennesseans, because you have the votes and you can. This thing, it's a one thing to do something because you can do it, but should you do it?
Representative Garrett.
Thank you, Madam Chairman. I don't believe this is being rammed at all in anyone. This is in subcommittee. It's the process, right? It's a bill that you can speak on, that I can speak on, that you made committee members can speak on and listen to and snap and whatever you need to do, whether you voice your favor for this bill or unfavor for this bill, right? It's the process that we have. And if this process might have been in place back then, it may not have been such a heightened, sensitive time for what happened with conduct that we all should be able to provide to our constituents when we come down here, right? Instead of, we saw quite a bit of disorder, and this is just hopefully maintaining and clarifying this disorder, because you're in control. You're in control of your own behavior, your own conduct. This may never even apply. I hope it doesn't apply. I hope this never has to be used, but it does clarify what our Constitution already says. So I hope that the process going forward will be that clear in the event we ever have to go through what we did last year, which I hope we do not.
Thank you. One more question. Okay, you're recognized.
And then I'm done. I understand you're saying about we're all in control of our conduct, and we're definitely, no one can push you to do anything. I always tell my daughters, no one can make you do anything. So stop saying someone made you do this. No, you had the free will to do whatever you have to. But if you continue to push somebody into a corner and they feel that they have no recourse in order to do something, there's only so many times you can keep thumping me on my forehead before I can keep walking away, before I turn around and hit you in your mouth. And so my point is saying that you can only push, and we pushed. And I think that conversation that needed to be had at that time led to what we're doing now. And I think what we're doing is very reactive. And I'm just asking if you would think about just let's have a little bit more discussion about this and the implications of what this really means at this time, because the optics, I've said this before, the optics don't look really good. It looks like it's a vindictive type measure. And I thank you for your time. And I know you put time into this and you thought into this, but thank you.
Representative Garrett.
Thank you for those comments, and I would say this bill's not directed at anyone. It's directed at all of us that serve here in the General Assembly, because we're under the same rules as everyone when it comes to our behavior, that we're on the floor, either in the House or in the Senate. Thank you, Madam Chairman.
We do have another question from Chairman Powers.
And to the contrary, I want to thank you for bringing this bill forward. We've been through this process not on both sides of the aisle. I mean, you may not have been here several years ago our colleague, but it was like 9 years ago, 8 or 9 years ago, that we had to expel someone for sexual misconduct. Would we want their district to reappoint them after we have had over a 2/3 vote to expel that person? Would we want them reappointed? For the people out there that are holding the signs over their head, would they want them reappointed to this, back to this body for that reason? So it applies to everyone. It's not just one person or party, but to anyone. If you've got 2/3 of the vote of a legislative body, you should not be reappointed directly to that body. I even would go farther and say you shouldn't even be reelected. You shouldn't even have because if you've done something so egregious that you've been taking more than 2/3 of that body to be expelled, there's so many people right now, and you can probably name them being a lawyer. There's so many people that are right now that are not eligible to run for this body. It could be criminal reasons or whatever, but they're not allowed to run for this body. And I think somebody that has violated our rules, somebody that has done something that egregious should be one of those people that are not eligible to be reappointed or actually reelected to this body. Thank you for bringing this forward.
Thank you for your comments.
Do we have any more questions? We do, from Representative Dixie.
Just want to make 2 comments. One is that at that opportunity, I don't think that you can compare the 2 incidents together. Sexual assault or sexual misconduct is a lot different than yelling. 2 totally different things. Number 2, if this is something that it was really itching and dire, why didn't we take care of it 9 years ago? Why now at this point? That's all. And thank you, Madam Chair, for giving me a leeway and for us to have this conversation.
You're welcome. Yes, Chairman.
And thank you. And I know what you're saying about, and probably should have taken care of it then. To be honest with you, we should have come back and done that. But when we've had something as egregious as, I would call it an insurrection, some other people might not. But if you go look up the definition, the people that are laughing, go look up the definition of a body of an insurrection. You can't hold your signs over your head, but go look it up, the definition of a body, in an insurrection of a legislative body, and that's going in and taking over the business of that body while they are trying to do business for the government, for the people. And that is the definition
I would like
of an
to
insurrection.
remind you that to please be respectful of this committee. Go ahead.
Okay, thank you. Go look at the definition of an insurrection and see what it says. That what happened in our body was that when they took over the well during the business, when we're trying to conduct business for the state, that would be called that. So laugh if you want to, hold your signs up over your head if you feel that way, but he's exactly right. And no matter, and whether it was sexual misconduct or whether it's taking over the well of a body with a bullhorn, either one of those are so egregious that person should be expelled. Thank you for bringing this forward.
Representative Garrett.
Thank you, Chairman Powers. And I would say I wasn't here 9 years ago, but I don't believe in the history that we've had where someone has been expelled where their local body had reappointed them. So it didn't come up. There wasn't an opportunity to say, well, wait a minute, let's look at that language. And that language says this because that's not happened before. So this is sort of first impression here. So thank you for those comments, Chairman.
Representative Johnson. Questions have been called. We're ready to vote. All in favor of this legislation, please signify by saying aye. Those opposed, no. The ayes have it, and you move on to full committee.
Thank you, Madam Chairman
Uh-huh.
and committee.
Next up, we have item number 11, which is House Bill 1652 by Representative Bolso. We have a motion and a second. There are no amendments filed. Oh, it says there are no amendments filed. Okay, there is an amendment filed.
Yes, Chair Lady, there
Um,
is.
Do I have a motion and a second on that amendment? Do you have drafting code 012889?
Yes.
That is correct. Do we have a motion and a second on the amendment, and the amendment makes the bill. So let's go ahead and put that amendment on the bill. All in favor, please signify by saying aye. Those opposed, no. The amendment is on the bill. Representative, you're recognized for an explanation.
Thank you, Madam Chair. Good afternoon, members of the committee. This is also a bill like the last one that deals with Article 2, Section 12 of our Tennessee Constitution of 1870. It's a one-sentence bill. Article 2, Section 12, as all of you know, provides that each house of the General Assembly has the power to determine its own rules. And obviously, every year at the beginning of the session, our House as a body comes together and adopts rules. What this bill does is it makes clear that the judicial branch is not permitted to intervene in the rules that this body adopts. Article 6, Section 8 of our Constitution gives this body the power to alter or change the subject matter jurisdiction of any circuit courts, chancery courts, or inferior courts, which is exactly what this bill does. This bill will make clear that the House and the Senate, respectively, are in charge of their own rules without interference from the judicial branch. And with any questions, Madam Chair, I'm happy to answer.
Thank you for that explanation. Do we have any questions? Yes, Representative Dixie?
Maybe we should change this to the Dixie Committee. I feel like I carry a lot of weight on my shoulders here in this committee. But anyway, a couple things about this bill that gives me pause. Again, we're changing. We don't like the rules, so we change the rules again. This is called checks and balances. That's what this is for. That's when something happens that's so egregious that someone has an opportunity to say, wait a minute, let's slow down. Is this fair to everyone? Again, it goes back to you have the supermajority, you have the vote, so you can change the rules to anything. You could say only people can, when you're walking on the right side of the hallway, everybody needs to walk in a single file line. That's a rule that you could be in. No one can challenge that. Is that fair? Is it right? Can you do it? Yes. Is it right? Probably not. But so I think we have to give pause about some of the things that we do, because it does seem vengeful and vindictive when we make these bills. What's the purpose of this bill? Because you didn't like, because somebody didn't somebody challenged the rules. We don't have a reason to challenge the rules on a different level, to go to a third party to say, hey, is this fair to everyone? So I'm asking, my question is, what's the purpose of this rule? What are you trying to fix? What happened? What incident is so that has you so up in arms that you have to write a bill about it?
Representative Wilson?
Thank you, Chair Lady Rudder. Representative Dixie, I'm not up in arms about anything, but obviously we all take an oath to uphold the Tennessee Constitution as well as the U.S. Constitution. As you know, Article 2 of our Constitution vests the legislative power of the state, of the people, in the General Assembly. Article 3 vests the executive power of the state in our governor. And then Article 6 of our Constitution vests the judicial power in a Supreme Court of Tennessee, which has appellate jurisdiction only. When you look specifically in Article 2 for the powers of this body of the General Assembly, it states explicitly that each house shall determine its own rules. And so when you talk about each body of government, each branch of government staying in its own lane, that is what this bill accomplishes. We had an occasion in August of 2023 where the judiciary stepped out of its lane. They stepped into Article 2 and tried to interfere in the rules that this body properly adopted under Article 2, Section 12. What this bill will do is to make sure that that never happens again.
Representative Dixie?
Thank you for the explanation, but I would like for you to explain this to me. Maybe I just don't get it. So what's the purpose, or how do checks and balances work?
Representative.
Thank you, Madam Chair. Very good question, Representative Dixie. As you probably recall from civics class, there's nothing in the United States Constitution that deals with this concept of judicial review. When you look at the United States Constitution, Article 1 obviously establishes Congress, the Senate, and the House of Representatives, each of which is responsible for passing laws that comply with the Constitution. Article 3 establishes the U.S. judiciary, but nowhere in the U.S. Constitution does the Article 3 judge, either at the district court level, Court of Appeals level, or Supreme Court, have the ability to review and say that it's unconstitutional an act passed by Congress. That came about in an early case called Marbury versus Madison, which was a decision by Chief Justice John Marshall in 1803 that came out of James Madison's refusal or failure to deliver a commission to Marbury when Thomas Jefferson defeated John Adams in the election of 1800. And so this concept of judicial review was not part of the original founding of our country. It actually came about by way of a judicial decision in 1803 in Marbury versus Madison. What this bill does is actually respects the ruling of Marbury versus Madison, and it confines judicial review to legislative acts. If you look at Article 2, Section 1 of our Tennessee Constitution, it's clear that the General Assembly is vested with the legislative authority of the people. It's those acts that this body passes under Article 2, Section 1 that are subject to this thing called judicial review that was introduced in Marbury versus Madison. What we're talking about here is not a legislative act. We're talking about a rule that the House passes to determine how it's going to be structured, how it's going to be governed internally. Same thing with the Senate. There is no principle anywhere in this country that gives the judiciary the power of judicial review over internal rules of a legislative body. That authority for judicial review only deals with legislative acts as provided in Marbury versus Madison.
We have another question from Representative Dixie.
Again, and this is it for me, I promise. This is just, it feels like a concentration of power. And again, I think that's why we have the three different branches. And to make sure that one doesn't have so much power that it stands alone by itself. So we have to go back and look at this. And thank you for the history lesson and the law lesson as well. I didn't go to law school, but after talking to you, I feel like I have like a little bit of law. I've taken a law class. But my point is being that when we take these into consideration, there's a reason why we do this, and we do have those checks and balances. And it does feel like a concentration of power, and we have to spread it out to keep things fair and balanced. And that's the whole goal of us being here. You know, I think everyone here did take an oath to do right by Tennesseans. And this is an opportunity for us to do right. And just because we don't like something, we can't keep changing the rules. It's a 100-yard football field. We can't make it 110 or 95 yards because it's easier for us to score. So let's just think about that. And I can't support this bill because I just feel like it goes against everything and trying to keep everything equitable. Thank you. Thank you, Madam Chair, again for your
You're most welcome. Representative Bullseye, do you have any comments?
Just one final comment, Madam Chair, and that is, Representative Dixie, I'd love to have your support on this bill because it does exactly what you're talking about. It maintains the separation of powers in both the Tennessee Constitution, Article 2, Article 3, Article 6, and it's completely consistent with all federal precedent regarding the separation of powers. So if you actually look at the Constitution we're talking about, if you read the provisions, even if you read Marbury versus Madison, you'll see that this bill does exactly what you want it to do. It maintains appropriate divisions between our three branches of government.
Thank you for that explanation. We do have a request for testimony on this legislation. So without objection, we're going to go out of session to hear from. Well, first we're going to go out of session. Got to get that accomplished. And then we're going to hear from Miriam Abolfazli. I'm sure I butchered that. What, if you would just please state your name and who you're with for the record, and you will have 3 minutes.
Thank you. My name is Miriam Abolfazli. I'm a native Tennessean, and I'm here to state my objection to HB 1652. When I moved to Washington, D.C. to start my career, I worked in an institution with many internal controls that made sure the transparency and accountability was in everything we did vis-a-vis the immense amount of American taxpayer money that was entrusted to us. During that decade of work, I truly learned a very American value, that of checks and balances, one that I would share about as I would travel through the Middle East, training others about civil society and democracy. This bill goes against that American value of checks and balances and is undemocratic. It removes the oversight of the legislative branch by the other branches of government. It states that no rules or procedures adopted by the legislature can be brought to court and decided by the judiciary. And should you say, which I imagine you will, that this bill does not refer to the decisions or statutes of the legislature, but to the rules, to that I say, the principle is the same. The principle being that which is reflected in Federalist Papers 51, written by James Madison. James Madison wrote, "But what is government itself but the greatest of all reflections on human nature? If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this: oblige the government to control itself." Many Americans have thought themselves doing the bold and pious act by bending the rules of our democracy for something they believe is necessary and urgent. The sponsor himself has brought another bill that allows parents to use the courts as much as they want to sue educational institutions. So in one bill, the court doors are wide open. In another, the doors are shut completely. Again, reflecting this human tendency to want to change the checks and balances to reflect our own vision, a tendency our founders knew all too well and protected us against. I'm in opposition of HB 6052.
Thank you. Do we have any questions from our members? Seeing none, we're going to go back into session. Thank you. You're recognized for any last closing comments.
Thank you, Madam Chair. My only comment is that the comments that the committee just heard are actually unmoored from our constitutional history. The fact of the matter is that James Madison did not even include the issue of judicial review anywhere in the U.S. Constitution. That didn't come about until, as I mentioned earlier, until 1803. Also, the fact remains that Madison wrote in Federalist number 45 that the powers of the federal government are few and defined. Those of the state governments are numerous and indefinite. And all we're doing here, frankly, is applying exactly what our founders intended in all 85 of the Federalist Papers.
Thank you. Question's been called. All in favor, please signify by saying aye. Aye. Those opposed, no. If you'd like to be recorded as a no, please see the clerk. Your bill moves on to full committee.
Thank you, Madam Chair. Thank you, committee.
Next up, we have item number 12, which is HJR 803 by Representative Fritz. We have a motion. We have a second. There are no amendments. Representative, you're recognized on your bill to explain your bill.
This is a House Joint Resolution setting aside the month of July in 2024 as a time of intermittent fasting and prayer as a means of seeking God's blessing and humbling ourselves to receive His grace and His mercy on our state. I asked myself why this was needed to do this. And I look around me and I see Tennesseans killing Tennesseans. I see drugs pouring into our land and people dying. I see brokenness and despair in many families and 9,000 children who are in state's custody. And I look back in the history of our great nation and as a state, and we have faced great challenges during those times, and our leaders during those times called us into a time of prayer and fasting. We as members of the General Assembly have been called to address these issues, and I think we do well. I'm proud to get to be a part of this body and address legislatively those matters. I really found myself, Madam Chair, at a position of where else do I go? And so with this, and I'm sure you've looked through the amendment, there's lots of whereas statements there. But for those who can and those who feel called to do so, this amendment would set aside the month of July, the first of our fiscal year, just as a time of repentance and honoring God in our state. And I would offer quickly, because I know it's been a long afternoon for you all, and I've got the next bill, that our founders understood this. You'll see a quote in the words before you from John Adams. And I will quote I brought several. I'm going to quote one for time's sake. I don't want to cut this short, but I do want to be respectful of y'all's time. George Washington, in his first inaugural address, said, "The propitious smile of heaven can never be expected on a nation that disregards the eternal rules of order and right, which heaven itself hath ordained." And John Adams talked about our Constitution made for a moral and religious people. Certainly, we don't want to force anybody to pray that doesn't want to pray, and certainly we don't want to try to force anyone to fast who cannot fast or doesn't want to fast. But I think there's something right about setting aside this time in our state to just ask for God's blessing and His healing on our land. And with that, Madam Chair, I'd take any questions y'all may have.
Do we have any questions? I think so, from Chairman Powers.
Thank you, Madam Chair. I was going to thank you for bringing this forward. I really appreciate it. The only thing I was worried about, fasting the whole month. We don't have to do that. I mean, I can probably just make it a few hours at a time.
You're recognized.
Thank you, Madam Chair. I probably need to fast more than I do, but it's written in as intermittent, and in the words also for those who can, because not everybody can. Right. And sometimes fasting is not just the laying down of the food, but it's setting aside something else, just for our focus on the Lord. So thank you for that.
Thank you.
Thank you. Do we have any more questions? Questions been called. All in favor, please signify by saying aye. Aye. Those opposed, no. The ayes have it, and your bill moves on to full committee.
Thank you, Madam Chair.
I think you're up on the next one, which is item number 13, and that's House Bill 2190. We have a motion and a second. We do have an amendment on that bill, drafting code 013504. Is that correct?
Yes, Madam Chair, and that does make the bill.
Do we have a motion and a second on the amendment? And we'll go ahead and put that amendment on the bill. All those in favor, please signify by saying aye. Aye. All opposed, no. So the amendment is going on the bill. And Representative, you're recognized to explain your bill.
Thank you, Madam Chair. This bill, through the passage of this legislation, as the amendment we just discussed, the General Assembly, in accordance with Article 3, Section 5 of the Tennessee Constitution, will be giving authority to deploy forces to Texas. It establishes a limit of a brigade-size limit of force to be sent, that the governor could send without additional authorization. It also establishes a time limit on that deployment and a process by which that time limit could be extended if necessary. And I'll pause for just a moment here to explain my reasoning behind this. Article 3, Section 5 is really clear, I think, in our Constitution. I think we've hit another place in time
Certainly, we've had our Tennessee Guardsmen in Texas and other places, and we want and we should, and that's part of the mission. I'm a former National Guardsman. I spent lots of years in the Tennessee National Guard or Texas National Guard, and have deployed overseas in service with this great volunteer state, and absolutely supportive of doing so. And one of the missions of the National Guard and the Tennessee National Guard is disasters and things that, to help other states. And we've been doing that. And I'm appreciative to Governor Lee for doing so. This bill is really intended just to further empower our governor to be able to send additional forces if needed. It does go to a brigade size. If you look at the fiscal note, there's a significant fiscal note to this. I did that on purpose, recognizing there would be a fiscal note so that we would have an approximation of cost if we sent large numbers to support Texas. Congressman Green's office, on those reasons why to do this, issued the Congressional Committee on Homeland Security report, and it states that 6.2 million encounters with illegal aliens in 2023. And during that time, another 1.7 million illegal aliens evaded U.S. Customs and Border Patrol and entered the United States. It is clear that the United States is in the midst of an invasion at its southwest border. And that is a strong word. I recognize that. Governor Abbott of Texas a few weeks back declared the supreme authority of their Texas Constitution to help fend off this invasion. I had the opportunity with several of our colleagues back in the summer to go down to McAllen, Texas, and see with my own eyes what the border looked like. And it is out of that concern and what I learned in that trip. And we've reached this point where the governor of Texas has declared it himself an invasion, that I thought it was necessary to do this. So again, this is intended fully to authorize our state. So we as a legislative body are engaged in the process, have looked at the cost, and authorize the governor to be able to act to help the state of Texas. And with that, Madam Chair, I'll take any questions y'all have.
Do we have any questions? Questions been called. All in favor, please signify by saying aye. Aye. Those opposed, no. The ayes have it. You move on to full committee.
Thank you, Madam Chair and committee.
Up next, we have item number 14, which is House Bill 2094 by Chairman Kiesling. Do we have a motion and a second? We do.
Thank you all. Thank you for that motion and second. Madam Chair and members, this is something you've never seen me do before. I do not make it a practice to carry legislation on any committees that I'm a part of or chair. This is one that I committed to without knowing. So so I'm here, and I wouldn't dare just be disrespectful and saying I'm stuck with it, but I wouldn't. I'm not going to do that. But anyway, it's a good bill. As a matter of fact, House Bill 2094 is known as the Emergency Powers Renewal Bill. This, members, was actually brought to me by Kayla Garrettson. She is the legislative director of policy with the group Free Tennessee. Currently, over on the Senate side, it has on last week it did pass, recommended for passage. It was referred on to their Finance Ways and Means Committee. So we'll see what happens later this week, I suppose. But the talking points in this, but before I get to that, Madam Chair, I look to you. I do hope that I did request testimony, so if that is on the record. So okay, so allow me, if you will, to just quickly run through the 3 points, talking points, and then I'll defer back to you, Chair Lady, if you could go ahead and call the testimony up. But anyway, this legislation seeks to add a checks and balance system to the governor's authority to renew emergency executive orders. Emergency executive orders can be declared, of course, by the governor for a 45-day issuance according to current state law. However, currently, the governor has the power to renew and extend these executive orders with no limitations. Finally, the bill seeks to require that the governor receive the approval of the Tennessee General Assembly to renew emergency executive orders beyond now that 45-day initial issuance, if the executive order applies to more, and here's the point, to more than 48 counties. That concludes the highlight of my highlights. If I'll defer back to you, Chair Lady, if you would allow to go
Sure.
ahead.
First of all, do we have any questions for Chairman Keys? If not, we are going to go out of session. And we have Kayla Garrettson with us today. Please come up and state your name and who you're with, and you will have 3 minutes for your testimony.
And if I may, Chair Lady, if apologize, if I may, I encourage our members, please ask every question that comes to your mind. Don't ask me. You know what I'm saying?
We got it.
Drill her on
Drill
questions.
her.
Don't drill me
Okay.
when we come back into session, Chair Lady.
Go right ahead with your testimony. I interrupted you. Please go ahead again.
Oh, no worries. Is the microphone on?
I don't know.
You all can hear me? Okay.
Yeah, we can hear you.
All right. My name is Kayla Garrettson. I'm representing Free Tennessee. We are 501c4 that endorses liberty-minded legislation. As Representative Kiesling, thank you so much for your support today, stated current law allows the governor to call and declare states of emergency. He can do this via the executive order, via the declaration of attempt, or a proclamation. And when he declares these state of emergencies, they currently last for 45 days. However, he can renew and extend them for however long he would like. So that 45 days almost becomes null at that point. And this is a pretty big responsibility and power that you're granting the governor when he does this, as he can suspend any rule or law under these states of emergency. So the power that's been granted to the governor to endlessly renew or extend state of emergencies was actually granted in the year 2000. This was Public Chapter 946. So it's been in effect for about 24 years now. And we understand that a need exists to ensure government mechanisms can respond quickly and effectively to states of emergency. We totally understand that there is an executive authority for a reason. However, we just want to make sure that there is a checks and balances in government where in the instance where he could continuously renew and extend, we want to make sure that there is a check to that power. And so we're seeking to do that today through the Tennessee General Assembly. And so what this bill does is that if the governor does declare a state of emergency, and only if that state of emergency impacts more than 48 counties, that's 50% of the counties in the state of Tennessee, and he wants to renew that emergency order, then he would seek the General Assembly's approval. So with that, it is the duty of the state legislature to ensure it's an appropriate counterbalance to the executive branch. I will mention that 13 other states actually have this counterbalance, specifically for state of emergencies. Whenever their governors would like to renew or extend, they do have the General Assembly convene in order to approve of those renewals or extensions. I will say in regards to those 13 other states that do this, the 48 counties is very specific to Tennessee. That's something that we actually thought through. We want to make sure that we're not coming and convening and wasting taxpayer money to renew emergency orders for a tornado that maybe hit 4 counties, right? We have 2 fault lines here in the state of Tennessee. We have tornadoes that happen. We have snowstorms that come through. And we want to make sure that we're not holding up any kind of process for them to receive emergency help if they needed it longer for them 45 days. So this is very specific that this is a statewide emergency, something that impacts more than 50% of the state of Tennessee, then you would convene to renew. And then I did have a member ask me earlier today, and I just didn't have time to get back to their office, but I went ahead and at the 3-minute mark, no worries. I'll conclude on that.
I'm sorry.
No worries.
Do we have any questions? We're not going to grill her. We have no questions. You have your question. You're
Well,
going to question. Okay,
I
Chairman
just want
Keesley.
thank you. Am I allowed to? I just want to make it perfectly clear. No one has a problem with the governor. We're not trying to I want to make that perfectly clear. You certainly don't. Free Tennessee, of course, it is not. And all this is just trying to put a little bit of I don't know. You best said it first. I think you've already said it, but anyway, it's just not. We just feel like there may be times when we as a legislature need to step in. So whoever the governor is, but anyway, with that, but thank you, Madam Chair.
Representative Alexander.
Thank you.
You're welcome.
Chair Lady. What would be the reason the governor would want to do a state of emergency past 45 days? What would be the reason?
Well, we did experience this out of the 24 years one time, and it was during COVID-19, and he continuously renewed orders.
Okay. And my question, I think I asked you today when you were in my office, was what if we can't convene?
Yes, ma'am. Thank you so much for asking. I was just about to answer that.
When your time ran out.
Yes.
Okay.
Thank you so much for asking. So the question was, what do we do if the General Assembly cannot convene? So I actually went after it. I was posed with this question and referred back to the Tennessee Constitution and then, of course, Tennessee Code as well. Currently, there's no stipulation in the Tennessee State Constitution or existing Tennessee Code that mandates that the General Assembly convene in person or specifically in Nashville or in any other designated location. So consequently, if circumstances arise where physical assembly is hindered, the General Assembly could convene in any manner capable with the state emergency, enabling its functioning. Additionally, each chamber retains the ability to establish rules and procedures for such exceptional sessions. We see this pretty much every special session we come up. We have to adopt new rules for that specific session. And so that's what my answer to that would be, is we could convene in some sort of fashion.
Thank you.
Yes, ma'am.
Thank you, Madam Chair. Just wanted to mention, do some states have it where they can renew it like one time before they convene? I mean, I think I had seen that somewhere that they do have one renewal before they'd have to convene, which would put it at 90 days or whatever.
Yeah, so the renewal would be, there's actually nothing that says that when you renew right now that it would last for another 45 days. That would only be because technically an executive order expires after 45 days. So if he's seeking renewal of that emergency order, I could see how that would be something. But because this is requiring a joint resolution, the governor can amend emergency orders, and he does so quite often. In fact, in a lot of those past emergency orders, a lot of the ones that were following it were amendments to a regular, like the initial emergency order. And so if that were to happen, if we're to say, let's say there's an emergency that happens, it goes for 45 days, he seeks renewal. What I would recommend is that the General Assembly would then have to speak with the governor, and in that joint resolution, you would have to spell out that how long the renewal would be for.
Okay.
Yes.
All right. This one other thing, and you might want to change the words just a little bit because I just noticed it has to be more. It says more than 48 counties.
Mm-hmm.
I think that should be more than 47 counties or 48 counties or more, because
Okay.
right now you're saying 49 counties, which
It's a
actually
little
only
bit
need
over
48.
50%.
So no big deal, but that might be one technical change you want to make.
I
Okay.
appreciate that.
All right. Thank you.
Do we have any more questions? If not, thank you very much for being here with us today. We'll go back into session.
Thank you.
Chairman, you're recognized for any comments. Chairman Kiesling, any comments?
No, not at this time, Madam Chair. Thank you.
Okay. Are we ready to vote? All those, do you have a question? You don't have a question? Okay. We're ready to vote. All in favor, please signify by saying aye. Aye. Those opposed, no. The ayes have it. And I guess we move on to full committee. Item number 15, House Bill 2114 by Chairman Powers has been rolled 1 week. And item number 16, HJR 849 by Chairman Powers has also been rolled for 2 weeks. And with that, I will entertain a motion to adjourn. We are adjourned.